Once we complete all the fact allegations, we then move into the legal theory cause of action or count allegations. If we just have one cause of action, then we just keep numbering the paragraphs straight through. We don't have to put in any headings. If we have more than one cause of action, so say we have a negligence cause of action and a breach of contract cause of action in the same case, both causes of action arise out of the same event or transaction, then we would label them. So say our last paragraph number for the fact paragraphs is 12, then we would have count 1, negligence, and would be a heading in the middle of the page. And then the next paragraph number would be 13. So the paragraphs are still numbered consecutively. It's just that you would break out each cause of action into a separate count, and you could have as many counts as is necessary. So they talk about this in Rule 1020 of Pennsylvania Rules of Civil Procedure, that the plaintiff may state in the complaint more than one cause of action against the same defendant. Each cause will be stated in a separate count containing a separate demand for relief, which is the prayer. And so just depending on what kind of litigation your attorney might be involved in, you might find yourself having multiple count allegations. So when you have a multiple count allegation, the first paragraph of each count must be it's called different things, a reference or incorporation paragraph, which is basically like a fancy ditto mark, because each count in theory should be its own complaint. But that would be really cumbersome and inefficient to have to rewrite all the jurisdiction, venue, and factual allegations within each count. So what we would do in our first numbered paragraph under each count is have a paragraph that says something like plaintiff reincorporates and alleges herein paragraphs 1 through 20 above. And there's different ways of saying it. That is just one way of saying it. But this is allowed under Rule 1019, Part G. Any part of a pleading may be incorporated by reference in another part of the same pleading, or even in a different pleading in the same action. So that is always going to be our first paragraph in each count. Then after that reference or incorporation paragraph, then you're going to list the elements of the cause of action, your legal theory of recovery, as they apply to your particular client's case. So for instance, if we have a negligence case, there are basically 4 elements of negligence: duty, breach, causation, damages. And this is what you're going to be doing for your assignment. So we're going to go into this in much more in depth when we get into the assignment. But in theory, what you would have is you would have one numbered paragraph alleging defendant's duty of care owed to the plaintiff. And you would just have to draft it in a way that makes sense for the actual situation where defendant harmed plaintiff. It would be different. What you're alleging for a car accident would be different than what you're alleging in a property accident. Then you would have another paragraph alleging how defendant breached that duty. Then you'd have another paragraph alleging that defendant's breach actually caused plaintiff's injuries. And then you would have a paragraph stating what plaintiff's damages are. And as you are laying those out, you're going to obviously reference the appropriate facts that support that particular cause of action. So under the rule, each element of the cause of action should have its own paragraph. In practice, this doesn't always happen. For our assignment, we're going to do it that way. So we have negligence, we have 4 elements. You're going to have 4 paragraphs in each of your counts in addition to that incorporation paragraph. Think of it this way: each element is a material allegation. So the breach element's a material allegation, the duty element's a material allegation, and so on. And sorry about that. And also keep in mind, and I realize this just cuts off a little bit at the bottom, that if we do not appropriately allege a cause of action, that opens up the possibility of defendant asking the court to dismiss our complaint. I already talked a little bit about how people sometimes have very sad stories, but there's not a legal basis for recovery. If we don't allege an appropriate legal basis for recovery in our pleadings, the other side can come in with what is basically a motion to dismiss, and the court could end up dismissing our complaint. We don't want that to happen. Now, we could amend our complaint and we could fix it under most circumstances, but we want to do it right the first time. We don't want to open up our client to this potential loss of their case at this early stage. The other part of Rule 1019 that I want to mention is Part I. This is not the case with what we're drafting this semester, but we will be doing this next semester with some of the assignments. And that is, if there is a writing that supports your claim or defense, you can attach that writing to your pleading or other document you're filing with the court. The rules specifically allow this. So when a claim or defense is based upon a writing, the pleader shall attach a copy of the writing or the part of it that is material to the case, and that is a requirement. So for instance, say this was a breach of contract case and we were alleging a breach of contract. In our count allegations, we might say something like plaintiff and defendant entered into a valid contract for the sale of widgets on March 1st, 2017. Attached is a true and accurate copy of said contract as Exhibit A. And then we would label the contract Exhibit A and we would staple it to the back of our complaint. And so we do that frequently when we file documents in court, including pleadings. Now, again, for our assignment, we will not be doing that, but we will be doing that next semester with some of our assignments. So we get through all the different elements and allege all the elements of our cause of action. And when we are done there, we are able to then talk about our prayer for relief, which is Rule 1021. And again, as I already mentioned, the prayer always begins with the word wherefore. The Rule 1021 states that each count must have a prayer. So after count 1, you'd have a prayer. After count 2, you'd have a prayer. That's how we're going to do it for assignment purposes. You do sometimes see it in practice where there's just one prayer at the end of the document, but we're going to follow the rules for our assignments. And again, the prayer is asking the court for the relief. So we can't just say, here's our story, and please find in our favor. We have to let the court know and let opposing party know exactly what we are seeking. So are we seeking monetary damages? What kind of monetary damages? Do we know the amount of damages? Are we looking for injunctive relief, equitable relief? We have to state that. The prayer is not a numbered paragraph. It's not an allegation. It is a demand for relief or request for relief. Some counties, and Dauphin County is one of these, Dauphin County requires parties, when they're claiming damages under $35,000, to go to arbitration first. This is not binding arbitration, but you have to go to arbitration first before you can file in court. So what the plaintiff has to do when they file their lawsuit, and they could put this somewhere else in the complaint, but we're going to put it in the prayer. We're going to state that our case falls outside the jurisdictional amount required for arbitration, meaning we don't have to go to arbitration because we're asking for more money than what is necessary to go to arbitration. If we had a case where we had to go to arbitration first, we would state somewhere in the complaint, and it could be in the prayer, but it certainly could be somewhere else, that the parties have already completed arbitration pursuant to Dauphin County local rules. So the court knows that these preliminary requirements have been fulfilled, because remember, if arbitration is required and we don't go to arbitration and we file the lawsuit first, defendant can come in and ask that the lawsuit be dismissed because we did not satisfy the arbitration requirement. So again, we do not want that to happen. And we will talk more in class about the different types of relief specific to civil cases. And then the last sections of the complaint is the verification and signature. So these are rules 1023.1 and 1024. So 1023.1 and 1024 basically get into a lot of detail of what these signatures mean on these documents. So 1024, that's rule verified. Complaints in Pennsylvania State Trial Court have to be verified. And so it is a paragraph that is put at the very end. So we would get through all of our counts, have the last prayer, and then after that we would have our verification paragraph. And the language can vary. It's not that it has to be the exact wording that we're going to use in our assignment, but it is language that basically says the party understands that under penalty of perjury that the allegations made are true and accurate to the best of their knowledge. And then the party signs and dates, okay? And that is the party basically saying under oath, this is what I believe to be true, and the party has to sign and date it. Then the attorney also is signing the pleading. Now, the reason the attorney signs is for a variety of reasons. One, it is their entry of appearance, and they have to sign a document if they're entering their appearance. So we have serves that purpose. But the signing also indicates that that the attorney has read the pleading, and by filing that pleading to the best of the attorney's knowledge, information, and belief, that what they're filing is true and accurate and has a basis for it. So it's not just a formality that the attorney signs the document. The attorney is verifying, I have read this. I believe there is a good faith purpose or a good faith basis for this claim or defense. I am not bringing this action for any improper purpose. I'm not abusing the legal system in any way. I am entering my appearance, and that I believe that there is existing law that either supports this claim or defense, or I have a good faith argument to try to change the law through this case. And this is all listed in Rule 1023.1. So it's a very important, the signature is a very important thing. This is not something that should be delegated to anybody. The attorney needs to sign it. Now, since it's usually the firm representing the client, any attorney in that firm can sign it. It doesn't have to be the primary attorney, but it has to be an attorney in the firm. This is not something that you should sign on their behalf. It's not something where a signature stamp should be used. And quite honestly, when you're drafting documents like this, and they're going to be filed, you want the attorney to review them, and you want that confirmation that the attorney has reviewed them. You can't force the attorney to read it through. Maybe you've done this type of complaint, 100 times, and the attorney is very confident you know what you're doing, and they just kind of give it a pretty quick look and then sign it. That's okay. You don't have to worry about that. The attorney has signed it. You have given the document to them and they have signed it. They are responsible. But you definitely want the attorney to review your work and sign it. There is a question, and the rules just have not caught up to the reality of electronic filing. Some counties have electronic filing. Federal court has electronic filing. Dauphin County, I don't believe they have it yet. I believe York County has electronic filing. Obviously, if you're filing something electronically, you're not really signing it the way we have traditionally signed them. And so with the rules not being clear on what to do there, it is something to keep in mind that you still want your attorney to review the document and okay it before you upload it into the, into the database of the prothonotari's office. So how the firm is going to do that is up to them. I had a student years ago who worked in federal court, and what they did is they would get all the documents ready. And, after the attorney reviewed them and revisions were made and they were ready to go, and they would get all the documents ready to upload, but they would make the attorneys actually hit the send button or the upload button. And that was a way that they were protecting themselves, which I actually thought was very smart. And I give this example in numerous classes. But you want to make sure that a lot of things can go wrong. You can inadvertently attach the wrong document. You could inadvertently attach an earlier version. The attorney may say, I didn't really see that. So you just really want to make sure that you know what the office's policies are, but that you are also comfortable that the attorney has reviewed that document. And when they say, yes, go ahead and file it electronically, that you have their okay to do that. And always keep in mind, document it in the client's file. per attorney's request, electronically filed complaint, and that should really cover you. So that is kind of the complaint sections in a nutshell, and we will continue this in more detail in class.